Okay, so we will start. We will start with the next topic, preamble of the Constitution. Okay, so now what we need to discuss here, you can expect a prelims question from here that they will ask you separately, like these words: justice, liberty, equality, fraternity. Okay, all these questions, all these concepts can be asked. Okay, directly from the preamble. Apart from this, you will get mains question as well, like what we have discussed yesterday, whether the preamble is part of the Constitution or is it not part of the Constitution. Can we amend the preamble? So the constitutional provisions and the Supreme Court cases or the interpretations with respect to that also we need to see. So here mainly, if you see, we are going to discuss about 3 cases. I hope you have some idea about that already. Berberry Union case, that is first one, important one that we will discuss. Berberry Union case. Then obviously Keshavananda Bharati case, this is also very important. Okay, so with respect to Keshavananda Bharati case, we will discuss in detail when it comes to fundamental rights. So we will have more features to discuss about this case. Okay, now there is one more case which is related to Keher Singh versus Union of India. So this also briefly I will look into. So these are the 3 cases that we are going to see in this discussion in this chapter. But what is preamble? We will just quickly look into what is preamble. Preamble is actually, it is nothing but the summary, right? So when I say preamble, it is actually the summary. Rather than reading the complete constitution, if you just go through the preamble, what you can understand, you can get the summary of the constitution from here itself. Now, is it mandatory that a constitution need to have a preamble? No, it is not mandatory. It is not compulsory. But we have preamble. So how does this preamble is actually going to help us? It will give you the summary. So that is how it is important. Or this is the philosophy of the constitution. Or you can, from the the preamble itself, you can actually understand what the constitutional makers intended, or this preamble is actually a key to unravel the expectations of the constitutional makers, so constitution makers. So in case any problem with respect to interpretation of anything, if there is any ambiguity, what the Supreme Court will do for interpreting any provision, they will mainly look into the preamble. And also there is one more, DPSP. So in case of any ambiguity with respect to interpretation of any provisions, actually the Supreme Court, it will actually help the Supreme Court to clarify that with the ideas which is enshrined in the preamble. So these are the concepts that we need to discuss. Now from where it is coming, what is the authority and which date it is, everything you will see from the preamble. So if you look into this, what is preamble? The people of India having solemnly resolved to constitute India into a sovereign. So I will tell you what is sovereign, what is socialist, what is secular and democratic republic. So you need to have clear idea about all these 5 terms, out of which the sovereign and the secular, etc., which will be added later. That also I will discuss in the 42nd Amendment Act. So when I say it was something which was added later in the preamble, 42nd Amendment Act, now the question comes, can you amend the preamble? Okay, so this is another question, amendability of the preamble. Yes, you can amend the preamble, and this 42nd Amendment Act actually held valid by the Supreme Court on the ground that the first question that I have raised, what was the first question? Whether preamble is part of constitution or not. So the first case that I have told you, in the Berberry Union case, it was held that preamble is not part of constitution. This was the initial interpretation of the Supreme Court. The preamble is not part of the constitution, but later in the Keshavananda Bharati case, it was held that preamble is part of the constitution. Now, if preamble is part of the constitution, just like any other provision in the constitution, you can amend the preamble as well. Okay, so if you can amend the constitution, like in the very same way, preamble is also part of the constitution, you can amend the preamble also. But what is the condition? The basic feature, the basic structure doctrine, right? It should not be changing. So you cannot simply remove this word. You cannot remove justice, liberty, equality. These words you cannot remove because these are basic features of the constitution. So you cannot change that. But can you amend the preamble? Yes, you can amend the preamble. That is why there was this 42nd amendment in which preamble is amended and this word so secular was added, and then again integrity, unity and integrity, this was also added in the 42nd Amendment Act. We'll come to that. So there is a preamble. Justice. So when I say justice, this is a comprehensive justice, social, economic and political justice. What is social justice? What is economic justice? Political justice we'll discuss now. Everything is there. Liberty, equality and fraternity. Okay. So now with respect to this also, we the people of India having solemnly resolved to constitute. So from where this the preamble is getting that authority, it is basically from the people of India. So when I say we the people of India, can we say I am also part of this or you are also part of this? Yes. But the question was raised in this case, Keher Singh. I have told you just before this case, in the Keher Singh case, it was raised that with respect to this, there was a dispute. When you say we the people of India, this is the date on which the constitution enacted, right? So at that time we were not there, so how can we say we the people of India? So the Supreme Court conclusion in this context or the interpretation in this context, and that case has got settled over there itself, and no more such case will arise after that, because it has been clarified that this usage of this we the people of India is actually a legal fiction, and nobody can be nobody can challenge or question this in any court of law about with respect to this. So that matter, that question with respect to we the people of India, that has been resolved with the Keher Singh case. So the three cases that I have mentioned is related to the first one, Keher Singh case, Beriberi Union case, Keshavananda Bharati case. Keher Singh case is with respect to this, and in that Supreme Court concluded that it's a legal fiction and you cannot challenge it, you cannot question this in any other court of India. Beriberi case is with respect to the whether the preamble is part of the constitution or not. It was held by the Supreme Court that it is not part of constitution. Okay, because even without preamble also constitution is functional. Even if you remove this preamble, constitution is perfectly functional, and this is not enforceable in court of law also, and nobody is getting power through preamble, and neither your power is also not taken back by the preamble. So in this context, if it is not there, still with the constitution it will function. So in Beriberi case it was held that it is not part, but in Keshavananda Bharati case it was held that the final interpretation of the Supreme Court is that it's part of the constitution. So just remember this two case, and if you get a question in mains, you should be mentioning about this too. Now the question about amendability, if it is part of the constitution, just like any other provision under Article 368, you can amend the constitution. So you can amend the preamble as well, and that is why only once it was amended, that is in 42nd Amendment, there I've told you these words are added, okay, this sovereign, secular, etc. Okay. Now if you look into the ingredients of the preamble, about this also they have asked question in prelims. It shows the source or authority of the constitution. What is the source or what is the authority? It derives its authority from the people of India. So now there is no point in discussing this further. I have told you Keher Singh versus Union of India case. It has been held that it's a legal fiction and cannot be challenged in any court of law. So the use of this word, we the people of India, it is a legal fiction. When I say that we the people of India, I and you and everybody is part of it. It doesn't matter you were there or born on this particular day. No. Okay. Then it also shows the nature of Indian state. What is the nature? Sovereign. I'll tell you what is sovereign. Socialist, secular, democratic and republican polity. What is the objectives of the constitution? The main objectives, justice. In all ways, right? Social justice, economic justice and political justice is a comprehensive justice. Liberty, equality, fraternity as the main objectives. Also, this you will see from the preamble, the date of the adoption or enactment of the constitution. Okay. Now, few questions here. The basic question. Is it enforceable in any court of law, preamble? No, not enforceable in any court of law. Is it conferring any substantial power to any of the organ of the government? Not giving any power to any of the organ of the government, nor it is limiting any of the power. Okay, so that is the reason why I've told you in Beriberi case, even without preamble also constitution will work and function perfectly. So it has been held that it is not part of the constitution. And is it compulsory that a constitution need to have preamble? No, it is not compulsory. It is customary rather. Okay, so it is optional. It is customary. Now what about 1935 Government of India Act? Does it have a preamble? No, it didn't have a preamble. So what is actually the preamble? It shows the summary, or it shows the philosophy, or it shows the main theme of the constitution. Okay, so Dr. D.D. Basu is of the opinion that this is the philosophy or the theme of the constitution, and it is the key to unravel the minds of the constitution makers, what they wanted to do or what they intended to tell. So in case if there is any dispute between any provisions in the constitution, okay, see, you will see no discrimination. As what is Article 15 talking about? I'll come to this when we discuss about fundamental rights tomorrow. We will be starting fundamental rights, the most important discussion. Article 15 says it's talking about no discrimination, right? Then what about reservation? Reservation is against this principle, right? So when the case was raised with respect to this reservation by challenging this provision of the fundamental right, so Supreme Court actually referred to the preamble, then gave that validity. They held that reservation is valid because it is part of social justice. So when you say equality, the constitution guarantees equality. So this equality involves not only equality in opportunity but also equality in status. So if you need to get this equality or provide equality in status, you need to support reservation. Okay, so in fact what Supreme Court interpreted is that it is not against the Article 15, rather it is supporting Article 15, and the reservation is understood as complementary rather than contradictory to Article 15. So from where Supreme Court was able to interpret in this way, it is basically from the preamble. That is why I have told you the importance of the preamble in case if there is any ambiguity with respect to any laws formed or any changes which is there in the constitution, or to interpret any provisions of the constitution, you simply look into the preamble and also DPSP. Guys, when I discuss about DPSP, there are two most important DPSPs like 39B. I'm going to stress a lot on this too, 39B and 39C. I don't want you to remember each and every DPSP, but obviously you might have read Lakshmikant and you know what is Gandhian principle, what is socialist principle and everything. You have some idea. Even if you don't mug it up, you can logically answer that. But these two, this is going to be very important not only for your prelims but for your mains also, because you know when you discuss about what is this 39B, 39B is related to the material resources of society should reach all. That give a kind of socialist setup, right? So the resources of society should be used for the benefit of all. So there is an element of socialism here. Similarly, no concentration of wealth. So because of these two provision only, actually government could go with what this land ceiling, right? In land ceiling, what actually happened? You have recovered the land of those people who have excess amount of land beyond the ceiling. So how is it possible for the government? Because of this, okay, land ceiling, even nationalization of bank. So when I say nationalization of bank, it was like your vocation, your right to employment, your right to do the business, right? But when the government is nationalizing the bank, means that right is compromised. Okay, so under which Article 19 clause 1, 19 clause 1G and 19 clause 1F. See, at this point of time when I talk about this 19 clause 1F, G, etc. and this, I'm sure some of you might have some problem, but we are going to discuss about DPSP, so we'll discuss this in detail. We are going to discuss about fundamental rights, so I will cover this anyway in detail. But I'm just giving you a importance of what at this level we are talking about preamble. So what is the significance of preamble is what I'm discussing now. What is the significance of preamble, or why is it important? As I've told you, it shows the summary rather than reading the complete constitution. See, if you don't have time to read constitution and understand constitution, just go to the preamble, read that, you will understand the complete idea of the constitution makers and the constitution. So it shows the summary, it shows the philosophy or the theme of the constitution. That is the reason why Supreme Court using the preamble in case any ambiguity between the any laws formed or with respect to any interpretation of the constitution. Okay. Now one more point, this is also some of the students have confusion. Can preamble override any specific provisions of the constitution? Preamble on one side and any provisions, any article on the other side. Can preamble override this? No, that is not possible. Okay, so in this context, that particular provision of the constitution is actually superior. If there is any clash between the preamble as well as any particular article, okay, so this will prevail. That is also very important. But again, I'm stressing on this point, in case if there is any ambiguity in interpretation of any laws or any provisions in the constitution, Supreme Court will refer to preamble. Okay, why referring to preamble? Because that is the key to unravel the minds of the constitution makers. What the constitution makers intended to say through the entire constitution, through all these articles, is actually reflected here. So if you need to read from the eyes or the minds of the constitution makers, go with the preamble and see whether the one in question is satisfying or in alignment with the preamble or not. Okay, so as I've told you, these are the 3 key points that you need to remember, not these 3, 4. With respect to these, they have asked the question. It shows the nature of the state, objectives of the constitution. In fact, you can see the preamble is actually talking about ideals and the aspirations of the people of India. Okay, what are the ideals? Ideals are justice, equality, okay, liberty. Guys, they will ask you specifically what is the meaning of liberty. Okay, like that also these days. Obviously the theoretical part is almost over. Now they are coming to the concepts and these kind of questions also picking up, and they're asking fraternity, like brotherhood. Okay. Then what are the aspirations? The other side. What are they? Secular, democratic, sovereign, socialist, and then republic. Okay, so if India can, if India is like this, if India is secular, if it is democratic, if it is sovereign, if it is socialist and republic, then we can achieve this: justice, equality, liberty and fraternity. So this is the idea. So this is ideals, this is the aspirations. Through this we need to achieve this. Okay, so again, I'm stressing on this part. Preamble, what is that? It is the summary, it is a philosophy, and the preamble will help in the legal interpretation of the constitution provision, and it is not enforceable in any court of law. Okay, it does not give any power to any government organs, neither it is limiting any powers as well. So just keep these points in mind. Now we will look into the different terms in the preamble. So this also, the 42nd amendment also, you need to remember what are the words which are added: socialism and secular and integrity. Okay, so these are this was also asked in the prelims. Recently they have asked. With respect to whether the preamble is part of the constitution or not, what is the conclusion? Ultimately, you just need to discuss the 2 cases, or you can say traditional view was like this. Which case? You can talk about Beriberi case. Okay, Beriberi Union case, preamble is not part of the constitution. Modern view is about, you can talk about Keshavananda Bharati case. Yes, it's the part of the constitution. Third important point that I need to discuss is related to the amendability of the preamble. Can you amend this? So whether this 42nd amendment is valid or not, it is held valid by the Supreme Court on the ground that since preamble is part of the constitution, just like any other provisions in the constitution, under article 368 you can amend the constitution. So since this is also part of the constitution, you can amend the preamble. Okay, so these are the key points that you need to look into. Sovereign. What do you mean by that? when I say sovereign state, there is no authority above it. So when you say India is sovereign, we don't have any authority, no other internal as well as external authority over the government. The government is superior. Okay, so no other authority is there. Socialist, when I say socialist, it is like there are socialist principles in directive principles also. Guys, this is again very important point. The Congress party itself adopted, you don't want to know the party, a resolution to establish a socialist pattern of society in its Avadi session 1955. Indian brand of socialism is a democratic socialism and not a communistic socialism. When I say democratic socialism, this is what you mean by mixed economy. Okay, mixed economy means both the private sector as well as the state, both will coexist. Okay, and that is the better way to remove poverty and inequality and all. When I say communistic socialism, it is a state socialism. What does that mean? State owns all the property. There is no concept of private property there. Okay, now in India it was like more, we are definitely a mixed economy, but till 1991 if you see, we are a mixed economy with a tilt towards socialism. Post 1991, we are a mixed economy, there is no change in that, but a tilt towards capitalism after the LPG. Okay, all these are coming here. So new economic policy, liberalization, that you can diluted the socialist credential. So we still mixed economy, but they have used this word diluted, means we have a tilt towards capitalism. But again, if you see from 2005 onwards, guys, when we went for this LPG, what was the expectation? Why we did that? Obviously that forex crisis and economic crisis, forget about that. Apart from that, when you're opening up your economy, when you're doing all this such drastic economic measures, it is expected that the poverty will come down, unemployment will come down, employment opportunities will increase, inequality will come down. These are the expectations. But contrary to this expectation, what happened is, instead of poverty coming down, poverty increased. I'll tell you the reason. Unemployment increased. That means employment opportunities decreased. Inequality increased. Why? The reason is, we are expecting investment, right? More and more investments are coming, so more employment opportunities will be created. So unemployment is over, inequality will be over, poverty will be over. But what happened? The investments have come, but these are not labor intensive investments. These are capital intensive. So what happened? And mostly in service sector also. So this labor actually in fact cut down. So employment opportunities have come down. Unemployment in fact increased. So government understood that if you need to solve these problems, government intervention is necessary, at least in countries like India. So government intervention, you can see it will start increasing from 2005 onwards. Like you will see these programs like NREGA, right, Food Security Act, and all these programs you can see post 2005, mid of 2000s onwards, you will see more government intervention. In fact, post 1991, this government intervention actually reduced, because we are expecting what? When we opened up our economy through LPG, what is the expectation? The market will solve the problem. What is that called? Trickle down approach. But does that happen? Trickle down didn't happen. In fact, it will happen. If you look into the countries where trickle down happened, it took over a period of time. It take long period of time, long time it take, okay, to trickle down to happen. But we couldn't achieve anything, so government intervention was necessary. The point here is, I hope you understood what I mean by socialism. Our version of socialism is not the Marxian version of socialism or the communist version of socialism. That is democratic socialism. It's a mixed economy. That's what you mean by socialism. Okay. What about secular? When I say secular, there are different interpretations with respect to secular. It can be, irreligious or non-religious, anti-religious. But what is our version? It is like Indian Constitution. We follow a positive concept of secularism. What is that? All religions in our country, irrespective of the strength, whether you are a majority or minority, have the same status and support from the state. So it's not that state do not support religion, or the state, it is not the case that it is irreligious or non-religious. We follow the religion. Everybody, if you want to follow religion, you can follow the religion. and not following religion is also your fundamental right. Okay, following religion we will be discussing about under various articles. I have just mentioned here article 25 to 28. Okay, it is directly there in Lakshmikant only, under which following a particular faith or religion is your fundamental right. Not to follow that is also your fundamental right. So our brand of secularism is different. It's a positive concept. We treat every religions equally. That means every religion have the right to coexist. Okay, so that is what you mean by our version of secularism. So democratic, that we know, parliamentary form and all. We'll discuss what is parliamentary form and all, democracy. So when I say republic, what is the difference between republic and monarch? So in case of republic, the head of the state, that is the president, is elected. On the other hand, if you see Britain, there it is monarch, right? It is hereditary. But in case of India, it is elected. So republic. From where we borrowed this? I've told you this before when we discussed about the features which are borrowed from different other countries. France. Okay. Justice. We will discuss the three types of justice: social, economic, and political justice. So what do you mean by political justice? Every citizen, irrespective of caste, religion, sex, or your economic status, are you allowed to vote? Yes, you are allowed to vote. Are you allowed to contest election? Yes, you are allowed to contest election. So this is what the political justice. It doesn't matter you belong to upper caste or lower caste. It doesn't matter whether you belong to upper class or lower class, or you're a Muslim or a Hindu, or you're a South Indian or a North Indian, right? So irrespective of all these region, religion, caste, sex, or economic status, you have the right to vote, or you have the right to participate in the political happening of the country, whether to vote or to contest election. What about the next one? Social. What do you mean by this social justice? So you will see all these article 15 to 18, it is all related to social justice. Just before I've told you this right to equality, even equality of status and opportunity is also part of, social justice. Economic. So when I say economic justice, the fundamental rights, you can again through fundamental rights, your right to public employment, right? So no discrimination in the public employment. Secondly, right to vocation. So this is also your fundamental right, and this is what just before I have raised, right to vocation. It has been in dispute, or it has been challenged in the case of bank nationalization. We will be discussing about all these in detail when I discuss about fundamental rights. There are a lot of cases we need to discuss over there. Okay, so social, economic, and political justice. What do you mean by liberty? Liberty, guys, this is very important. Okay, this word they have asked, what is the meaning of the word liberty? So liberty means absence of arbitrary power exercised by the government or individual. So no arbitrary power. Okay, neither by the government nor by any individual. Any doubt? The fraternity means, in simple terms, if you need to, you can read all these. But when I say fraternity means, it is basically brotherhood. Okay. So I'll quickly go through these provisions again, these important elements again. If you have any doubt, we can discuss further. I hope this is clear. Sovereign means the government of that state is superior. Okay, no internal. But do you think in the era of LPG, or in the era of this connectivity and communication, and with respect to all these international organization and all, are we really enjoying the sovereignty? Or are we coming under the pressure also of this WTO? Many times we have changed our provisions because, see, guys, if you see the Patent Act and the modification, the changes in the Patent Act, earlier, what is that what we have followed? We have followed this process patent. What does that mean? Process patent. If you are making a product X, okay, so you will not get the patent for this product X. You will be getting the patent for the process in which you come across this. What does that mean? It means some other person also can create the same product but through different process. You cannot use the same process, whether it is a software or anything. You cannot use the same process. Okay, you can follow the different process, but you can come across the same product. What is the advantage here? The advantage is, see, somebody come up with a product, it is useful for the society, but it might be very costly. And if you are allowing the process patent, nobody will follow this process. As long as you are not following this process, you will try to innovate more. And when you try to innovate more, what can happen? The cost can come down. That means more efficient and better production of the same product can come. But imagine the situation, if you're going for the which patent this imagine the situation, if you're going for product patent, that means somebody have made this product. If you're giving patent to the product, can anyone, for example, you have come up with a cancer drug for the cancer, so this cannot be made by others again. It doesn't matter whatever process you follow, you cannot make this. Is it actually acting as a big problem? Because what will happen, this person now have the exclusive right over this product. He might have made it in a costly manner, so he will charge you too much. That cases and all, the Bayer cases and all, I'm not discussing at this point of time, that is related to economic WTO. But the guy who made this product can charge very high. But if you're allowing, okay, process patent you can give, but not product, some others can come up with more innovation over that, and the cost can come down. So which one is actually better? Process patent is better rather than product patent, because if you give product patent, if you are given it to someone, then no others can come up with the same product. That is really disadvantageous for the society, not for that person. Obviously this guy will enjoy the benefit for another 20 years in which he got the patent, and further he can extend that patent also, so he keep on enjoying that monopoly. But who is the loser there? It is the public who's going to be the loser, because the public need to get that, means you have to pay that price. Okay, so process patent would have been better. But what happened, why we changed to product patent, process patent to product patent? Under WTO guidelines we have changed this. So don't you think that we come under the severe pressure of WTO and we compromised our sovereignty? Guys, there are many other instances also where we surrendered, in fact, but you should not use the word surrendered sovereignty and all. But in fact, that is what actually happened in the case of Italian Marines. You will see, okay, so the deal with Italy. Let's not get into that, but I'm saying in this era it is slightly difficult to maintain that sovereignty also whenever you are facing this pressure from the international organization and in this LPG era. Okay, so yeah, it is written here, India's membership of the UN also. Okay, here it is written, no way constitute a limitation on such sovereignty. But the example that I've given you, what it says, it clearly shows that we surrendered to an extent our sovereignty. And that is the reason why we were very adamant on process patent. Okay, but we have changed it in the amendment which has been made. Not desirable, but we have done that. It is actually going to help more the developed countries, not the developing countries. Okay. So when I say socialist principle, it is related to directive principles and socialism. I hope you understood. Democratic socialism, mixed economy. Secular, all religions in our country have same status and support from the state. Can state support religion? Yes, state support religion. Can state support one religion? No. All religion equally. Okay. Democratic. Republic means elected head. Okay, not monarch. Justice, social, economic, and political. Liberty, against arbitrary use of power. Equality. All these articles we'll be discussing in the fundamental right. Fraternity, brotherhood. Okay, now the significance. This also I've told you, this is the basic philosophy and the fundamental values of the Constitution. It is the vision of the Constituent Assembly, reflect the dreams and aspirations of the founding fathers of Constitution. So if there is a question on significance or the importance of preamble, these are the points that you can highlight. It is the soul of the constitution and key to unravel the minds of the constitution, etc. Okay, so now this is the next question: whether preamble is part of the constitution. This is the first case that I've told you, Beriberi Union case. What is the conclusion in this case? You just need to know that preamble is not part of the constitution. Okay, Keshavananda Bharati case. In these two cases, what you need to remember: 1, 2. What about Keher Singh case? Keher Singh case is talking about we the people of India, that one. Okay, so it has been asserted by Supreme Court that it is a legal fiction, so you cannot challenge that anymore in any court of law in India. Okay, so Keshavananda Bharati case, it is part of constitution. Okay. This one not that significant. LIC of India case again held that preamble is an integral part of the constitution. Again, this is also very much important, guys. Don't skip this point. Preamble is neither a source of power to legislature or any organs of the state, nor prohibition upon the power of legislature. I've told this point. It is not justiciable. What does that mean? It is not enforceable in any court of law. So these 2 points need to be remembered. What about amendability? Amendability of the constitution. It has been held that in Keshavananda Bharati case that it is part of the constitution. So what is Article 368 related to amendment of constitution? So if it is part of the constitution, you can amend the constitution. So preamble can also be amended. But preamble, preamble can be amended subject to the condition that no amendments done to the basic features. But what are the basic features? Like justice, equality, fraternity, right? All these are basic features. So you cannot change the basic features, and that is not only in the case of preamble, guys. Any part of constitution, for example, federalism, is it there in preamble? No. But if you make some changes with respect to this federalism, it's a basic part of basic feature, right? Yesterday I've told you, you cannot make any amendment with respect to this. Okay, if you that has been asserted. Only once it is amended, 1976, 42nd Constitutional Amendment Act, new word socialist, secular, and integrity was added to the preamble. This amendment was held to be valid by the Supreme Court. So this is again very important topic, and that's it. Any doubt here? No, other countries also have preamble, not India's invention.
Hello.
Yeah, tell me.
Yes, sir. When we talked about on the one side there is provisions of preamble, and on another side there is provision of some article, then the article will prevail. Is there any example for it where they are contradictory?
No, in case if there is any contradiction, then the fundamental, not only fundamental rights, the articles will prevail. Because see, first the articles, the constitution has been made. Then after that, as a summary, the preamble has been made. So if there is any contradiction, the articles will held valid. That is what I mean to say.
Any example for it, sir?
Example, I don't know with respect to that.
Okay.
Yeah, USA have the first preamble. Yes. No, other states also. The written constitution, unwritten constitution do not have preamble, and it is not necessary that you need to have preamble. It is customary. Some constitution have, so it is not necessary that all written constitution also need to have preamble. Some of this will have, some of this will not have. US is the first state to have preamble. Okay. Unwritten constitution, no, right? That is not possible. Even constitution is not codified, so no preamble. With respect to that, I don't have any example, but I just know this legal position only. But again, that is open to the interpretation of the Supreme Court. So when Supreme Court is interpreting on the basis of preamble, then it will be held valid. Just before I've given you this example, right? Article 15, this is related to non-discrimination. But again, when you talk about reservation, so that is against Article 15, but Supreme Court actually looked into preamble to interpret this. So that is also possible. But in general, the legal position is that the articles of the Constitution will be held valid.
Sir. Sir, in Keshavananda Bharati case, the preamble is actually a part of the constitution. But sir, you have to said that it doesn't have any override over any article also. So sir, is that too is actually being contradictory, right?
No. When even though preamble is part of the constitution means why it is need to be contradictory?
No, sir. I'm asking that, sir. You told that, and preamble cannot override over any article. If such clash happens, then article will prevail. And the same time, we know that Keshavananda Bharati case is said that it is a part of the constitution. So when we take both the statements, this year one question came on preamble also that it is whether independent of other parts. One question came today this year's prelims. So when you said that, I got the point. So I'm just asking that if an article cannot override that, and the same time it is said that it is a part of the constitution also. So sir, is that too doesn't contradict or is the same?
No, it is not contradicting. It is not contradicting. What it says is preamble is part of the constitution, but preamble has nothing to do with the article. Preamble is the summary. Okay, it is part of the constitution, but it is not enforceable like any other articles. The other articles have its enforceability, like for example, fundamental rights. You can enforce it in court of law. Okay, but that's not the case with preamble. Preamble is part of the constitution. That is the conclusion in Keshavananda Bharati case. But preamble is not like any articles. Articles are specific, which is related to some specific aspect. Preamble is general in nature. That is the mind of the constitutional makers.
Okay, sir. Okay, sir. Thank you.
Arun, it is like when I say, see, post 1991, what happened? It is expected that when we open up our economy, the expectation is that investments will come. Okay, but this investment has come. A lot of FDI or whatever it is, it has come. But where it came, mainly in service sector. Okay, and we are talking about unemployment and we are talking about poverty. Okay, so service sector, the GDP is increasing or the GDP contribution of service sector is so high, but the contribution in employment is actually very less, right? So what I'm saying is those investments which has come, it is not labor intensive. It is not giving employment to people. It is rather like capital intensive. So you are not able to solve this problem of unemployment. Obviously, poverty instead of decreasing, it has increased. So if you look into the statistics, 1994, 95, even Planning Commission also said the same, that this poverty increased, unemployment increased, employment opportunities decreased because of this. You are leaving everything to the market. You are expecting trickle down to happen, but market will not produce for social justice, or market won't do anything for social justice. Market will do only if there is a need or demand. Okay, market will not if somebody is hungry, market is not going to give food for him as long as he don't have money, right? Okay, somebody need food, but he don't have money, so it won't create demand in the market. What is demand? Demand is the willingness and ability to buy. You may be willing to buy food because you're hungry, but you don't have ability. So his willingness to buy food will not create demand in the market. So nobody is going to produce for him. The point is market will not meet social justice. So simply market is not going to give you employment, right? So poverty cannot be removed. It actually, that is what actually happened at that time. So government understood that government intervention is required, and that is the reason why this post 2005 onwards, this MGNREGA government intervention was so high. Food Security Act, MGNREGA. After that, you can see poverty has decreased. Post 2005 onwards, if you see, poverty has decreased. You can see the statistics. Unemployment has decreased. Employment opportunities have created. Okay. So that is an example of mixed economy where the state intervention is high. State intervention is required. In fact, in our concept of socialism, state intervention is very much required.